Welcome to Civics in a Year, the podcast that makes civic literacy fast, accessible, and surprisingly engaging. In just 10 minutes an episode, we'll tackle one of 250 essential questions about American democracy, how it works, why it matters, and what it means for you. Whether you're a student, a teacher, or just someone who wants to better understand your country and your rights, you're in the right place. Civics in a Year is powered by the Civic Literacy Curriculum from the Center for American Civics and is produced in partnership with the School of Civic and Economic Thought and Leadership at Arizona State University. Welcome back to Civics in a Year. Today's Supreme Court case deals with affirmative action, and we have Dr. Beienberg with us. So, Dr. Beienberg, today we're talking about the Regents of the University of California versus Allen Bakke in 1978. This case is talking about racial quotas in university admissions, and I know that you're going to talk about other cases, one that has been actually very recent, but can you give us a little background on this case specifically?
Right. So one of the University of California medical schools is trying to increase its percentage of basically Black doctors is the long-term goal. Mm-hmm. And so they create a system that effectively creates a pretty strong preference for, in fact, effectively a de facto quota for the sort of the racial composition of their entering class. And a student who is basically not eligible for that extra pool, that sort of special pool, argues it is unconstitutional under the Equal Protection Clause and also Title VI of the Civil Rights Act, which I'll come back to.
Okay.
Arguing that effectively a governmental institution, which the University of California is both bound by the Equal Protection Clause and Title VI, which says that effectively no institution receiving federal funding can, public or private. So the Equal Protection Clause binds public government only. The Civil Rights Act, Title VI, is any institution taking federal funding. And that says that they can't discriminate on grounds of race. And so he argues he's both been discriminated on grounds of race and that equal protection has been denied to him. And the case, the original Bakke case, is pretty messy. 4 justices want to basically take a fairly straightforward, this is a clean violation of Title VI of the Civil Rights Act. The Equal Protection Clause can be fuzzy, but this is a discrimination based on race, and the University of California takes federal funding, therefore. So they want to strike it down, as Justice Stevens writes this opinion. Justices Brennan and Marshall want to argue that effectively the Civil Rights Act only applies to sort of negative discrimination, but not sort of, I won't say compensatory, but everybody agrees that if you've been specifically harmed on account of race, you can basically make a claim. But sort of generalized compensatory discrimination, they want to say that that's fine under both the Civil Rights Act and the Equal Protection Clause. And so you have effectively 4 and 4 saying unconstitutional and illegal, and 4 saying it's fine. And you have Justice Powell basically for himself writing this very, very idiosyncratic 5th sort of simple opinion, which is only binding on him. The lower courts will then sort of treat it as precedent, but it's effectively just a sort of tiebreaker. And Powell says that he agrees laws classifying based on race are presumptively unconstitutional, right? So he says, yeah, Brown has basically stood for this precedent. It's unconstitutional. He then he goes through sort of specific justifications that have been offered by the University of California. I'm just going to focus on 2 of them. One is they say we need to be able to do this to help remedy generalized racial discrimination. Not a particular individual can point to a racist policy that he then suffered from, and therefore, like, he's being forced to be admitted to a school, right? Everybody would say that's fine. But simply saying I am Black and Black Americans have been sort of generally discriminated against, Powell rejects that as an argument for affirmative action. He says generalized racial discrimination is not a legally justifiable defense of this. If someone had showed they were individually discriminated against, absolutely they would win. But you say there's this general racial discrimination, and so now an institution can in turn practice general sort of compensatory discrimination. So he says that's out. The only justification that he says is defensible, and this is a really odd thing, but this ends up being really significant to the way the American political debate shapes, is he says academia has effectively an academic freedom component to it. And so universities, as trying to build a sort of broadly intellectually diverse body of students, and he's very influenced by a brief that Harvard writes, where they say, look, we want kids from Idaho. We want white kids. We want black kids. We want people who've, military brats, whatever, right? So they say, we want to create a class that's basically a bunch of interesting, different people talking to each other. And Powell says that is effectively the only justification that he will approve here. So it's a weirdly sort of almost more of an academic freedom case in some ways, because he's sort of speaking completely aside from the way that we normally talk about racial discrimination issues. For him, it's effectively, he wants Harvard effectively to be able to sort of set its own class. And so Powell says, really, really complicatedly, racial discrimination is presumptively unconstitutional. Universities distinctly can practice a limited form of racial discrimination if it's part of he uses the word holistic a whole bunch of times, but a very sort of complicated system to build a diverse graduating class. But it ceases to be narrow if it turns into effectively a quota, where you say, we want X percentage of our class to be this race, Y percentage of our class to be this race. And so he blocks the policy there on the grounds that it's become effectively a quota if it turns into that level of discrimination effectively, that the thumb is that heavily on the scale. And so you can see why this is, for your lower court, this is almost impossible to try to apply, because discrimination is usually wrong, almost always wrong on racial grounds if by a government, except for the universities, except if the universities do it too much. And so, but the Bakke case effectively ends up, but with its focus on sort of intellectual diversity, is really the sort of origin of the sort of major sort of American discourse of racial diversity. That really flows from this case. In 2003, the Supreme Court, and so the Supreme Court continues to hear sorts of cases involving different kinds of affirmative action, and they sort of track Powell's thinking. In 2003, in a case called Grutter versus Bollinger, a majority of the court basically says yes, and this is an opinion written by Sandra Day O'Connor, says yes, we're going to go with Justice Powell's sort of framework here. So now it's not just sort of one justice. It has the precedential value of the court behind it. And you have different blocks of justices. You have sort of Ginsburg and Breyer taking something akin to the Brennan position, like, yep, no, this is fine to have compensatory racial classification. And you have sort of Rehnquist and Scalia and Thomas taking and Kennedy at the time saying, no, like Stevens and crew were correct. This is illegal under the Civil Rights Act and the 14th Amendment. But the Grutter case sides with Powell. Now, again, showing how complicated this is, they allow one affirmative action policy that is being implemented by the University of Michigan, but they reject another one on the same day. So there's a Grutter versus Bollinger, and there's a Gratz versus Bollinger. And so they say the one in Grutter is sort of minimal enough and vague enough that it's within the realm of sort of acceptable racial discrimination, but the other one looks like a quota, so that one is out. So those two cases basically make Powell's framework the rule of law. And then there's some cases in the middle that I'll skip, but then in 2023, in the Students for Fair Admissions case, the Supreme Court says, effectively using the framework that we've used for dealing with racial discrimination, which is called strict scrutiny, where it's presumptively unconstitutional, but you have to really tightly identify how the classification works. The court says universities have moved away from that. It used sort of vaguer and vaguer frameworks. And Grutter had also said, we're willing to basically turn a blind eye. The case does concede racial discrimination is happening. Powell concedes that, O'Connor concedes that, but say it's temporarily justifiable under these circumstances. And O'Connor's opinion says in 25 years, we expect this will be unconstitutional because the fit won't be close enough. So in 2023, a majority of the Supreme Court says effectively, the Grutter Powell sort of, this needs to be limited. This is now over, basically, that we need to implement that part of it, that the justifications have become sort of vaguer and more expansive in terms of government institutions. Again, specifically for higher education, it's worth emphasizing this isn't been generalized. This was never generalized more broadly. You have a concurrence. You have a dissent from Justice Sotomayor and Justice Jackson, basically saying the court gets it wrong on history. We should have never done this. You haven't really interested. You have Thomas basically fighting with Jackson on the original understanding. It's a really long, historically sophisticated argument, and you have Gorsuch effectively saying, look, there's a real and much easier way for us to do this rather than say how much is too much. He says we should have just gone back to Title VI of the Civil Rights Act, which says government institutions taking government money can't racially discriminate. It doesn't have a caveat. It just says very, very clearly in the text there. And so rather than sort of ignore the Civil Rights Act, that's what Gorsuch wants to do. The Roberts basically says, yeah, but the other people aren't asking us to rule on Title VI, so we can just sort of brush it aside. But Gorsuch wants to do that. So Bakke originally, again, held sort of summary of the framework here. Bakke held, consistent with Brown, racial discrimination by government, presumptively unconstitutional. Universities distinctly can practice a limited form of it to implement a diverse student body, diverse in all terms, but it can't be hardened racial quotas. Grutter basically implemented that, and the Students for Fair Admission case said that the universities, et cetera, have been basically taking that allowance and making it too broad, too wide. And so therefore, the normal rule of racial discrimination by government institutions that it's prohibited, like that needs to control here too.
And all of these cases, I mean, the Grutter one, and correct me if I'm wrong, that was the law school. Like the University of Michigan was trying to make their law school more diverse, correct?
Yeah. So the one was the law school case and one was an undergrad case. So that's so they turn out differently in that front. Yeah.
So when you talk about like, the discrimination is allowable in like these cases, it is to make things more diverse. But then in the Students for Fair Admission versus Harvard, those students felt like the quotas, for lack of a better word, were actually harming them and not allowing them to get in because they were only allowing so many of X race in. Because the Students for Fair Admission, weren't the students
primarily Asian?
Yes.
Primarily Asians in terms of the plane. I mean, it's a group, but the Students for Fair Admission was effectively like a lobby and an interest group. But the bulk of their brief focused on effectively Asian American students who basically were going to have a very small chunk of what the quota looked like. And so they were arguing that, that what their SAT score had to be compared to different groups was wildly different. And so therefore they were being actively discriminated against. That effectively their perspective is it's zero sum. Once you basically say we can make an allowance here, then and it's the same argument that Bakke had made back in the day, but that basically benign discrimination or compensatory or whatever it's called is zero sum, where unless this is actually one of the things that the dissents in the Grutter case argued, which is they said if you truly were concerned about diversity, then you have another way to actually do this, which is make your law school less selective. Expand it, change its SAT range, et cetera. Because under the strict scrutiny framework, you can only make a racial discrimination if you say this is the only way to achieve the goal that you're trying to seek. And Rehnquist and Thomas in that case said, if that really is your most important goal, then there's a really easy solution. Just increase the class size of the University of Michigan until you can get effectively a different band. So they argued effectively it failed even under the strict scrutiny standard.
And just to clarify and make sure everybody knows, we are specifically speaking about affirmative action in college admissions here because, like with everything else in the Supreme Court, there are no sweeping decisions. Everything is very, very specific. So, Dr. Beienberg, thank you again.
Thanks for joining us on another episode of Civics in a Year. If you enjoyed this episode, be sure to subscribe and share it with someone who cares about a constitutional republic as much as you do. For more episodes, resources, and updates, follow us on social media or visit us at civics.asu.edu. Make sure to check out the show notes for any relevant links. Special thanks to the United States Marine Band for their performance of the Stars and Stripes Forever. Let's keep building a stronger constitutional republic, one episode at a time.